Okay. Hearing here, attention.
But in this case, my lord, an 18 years old boy
Hmm.
have been in jail for about 11 months
11 months.
11 months.
Why?
for sexual assault of a 17 years old girl. My lord.
Ah,
My lord, kindly see page 30, my lord.
just a minute.
Before that, my lord.
One.
Twelve two. 12:5. Yes. Had we heard this matter before?
My lord.
Ah, that OBC certificate one, na?
Yes, my lord.
My lord wanted to decide only on one fact,
Hmm.
question only regarding the age of the petitioner. My lord.
Hmm.
Because he, as per the college authority, my lord, he has become overaged by 1 day on the date of submission of the application.
That submission we had heard on the earlier occasion.
Yes, my lord. So my lord wanted-
Something else had clinched the issue, that certificate. What?
No, that was the issue, my lord. I
That was
think,
the issue.
my writ petition was concerning regarding the NOC.
NOC, yes.
So your lordship, possibly, if your lordship remembers that on that day that I overcame. Your lordship said possibly that on the ground of NOC, we cannot curtail that.
Hmm.
Because the NOC through the department did not reach on the day of interview, but my personal copy which I submitted for the interview, that was, NOC was enclosed along with that application, when I submitted the application.
Hmm.
So possibly that was enough, my lord, because the
Okay.
depart. Then the question, my lord, in the subsequently, when the writ was filed, the question came that I am overaged by 1 day.
Hmm.
So that plea, my lord, I have taken I want, that under the General Clauses Act, Section 9, if from and to it goes, that possibly either of the day will.
If a man is born on the 1st of January, he'll be 1 day old on the 2nd of January.
Yes,
He cannot be 1 day old on the 1st of January itself. That was your argument.
yes.
Yes, you are appealing for?
College authority.
What do you say?
Lord, his 1 day access.
How?
Lord, the day when he is born has to be counted.
Has to be counted. He is 1 day old on that day. He has not crossed 24 hours on that day.
Let us be counted. my lord.
Huh? From where do you get that?
I have find one
Very
judgment.
interesting.
Kindly have para 13, my lord. 13 from para.
Oh, Supreme Court of India. Okay.
This is Indian Majority Act, my lord.
Hmm?
Para 13, my lord.
Of
Uh,
this judgment?
yes, my lord.
Where
My
is
lord
that?
comes to sub para.
In recognition
of
of the
ma-
difference between how a person is legally constituted and how it is understood in common parlance.
In computing the age of any person.
Indian Majority Act 1875.
Yes, madam.
Day on which he was born is to be included as a whole day, and he shall be deemed to have attained majority. If he falls within the first paragraph of section 3 at the beginning of 21st century of the day, 21st anniversary of the day, at the beginning of the 18th anniversary. The day on which he was born is to be included as a whole day, and he must be deemed to have attained majority at the beginning of the 18th anniversary of that day.
Then my lord, next para, my lord. On the basis of which the honorable court has observed, the section embodied that.
Hmm?
The next para, my lord.
We've read it. Now, this was for the post of a assistant?
Assistant professor, man.
Assistant professor. You have qualified everything, you are there on merit.
Everything.
Everything done. What about the last paragraph?
No, last paragraph, my lord, says that ultimately, my lord, the appeal was dismissed. However, the court observed that
Hmm.
if possible, then the petitioner, the department was directed, my lord, I'll read, my lord. Before parting with the case, we shall be failing in our duty if we do not advert to the undue harm.
Now we have a provision. We have a provision in
Where
the
is there, my lord, for relaxation of age, my
of
lord?
age in particular case
Yes, my lord, but that has
been done before he
Before
applies.
before that.
Now you allow him to participate and do everything. Even you did not think it is overaged.
at a
Is it
time-
not?
Yes,
Somewhere at the end of the selection process, it comes out that he's overaged. That is when you raise the contention that he is overaged. Now, if that be so, it is at that point of time he has to first pray for a condonation. It is
before,
because only at that point of time everybody comes to realize, and it is today on what day? Today is the 7th of May,
Yeah.
that we all realize that there is a Supreme Court judgment. He would be overaged. Is it not? Even till the last occasion, we were not on this. So when everybody's concept, including his and the selection committee, till that point of time, on the date of holding of the interview, was of the opinion that he would be entitled. He can go ahead. It is at this point of time he will pray for a condonation.
my lord,
If at all that is to be done, then the government will see if that can be condoned. They condone it. If not,
he can apply, my lord. He can apply.
then he. Have you
Authority
gone
will
through this
process.
judgment, sir?
No.
Please go through it.
Go through.
Please go through it. If you agree to what has been given by the.
No, I
Yes, sir. You want to say something?
I have the judgment, man.
Who is he?
Candidate who got selected in the interview.
Huh? You have been appointed. You are working.
No.
Then why does he say that you have been selected?
There is a stay ordered by this.
Then we'll let that stay continue till the government takes a decision.
No, my lord, I have filed my affidavit in opposition also.
True.
So there,
All it is all answered in favor of the respondents. If we go by the Supreme Court judgment,
yes, my lord.
we answer it in favor of the respondents that he was overaged when he applied.
Yes.
NOC part he has overcome. We will just refresh our memory and we'll decide on that. So far as his condonation, so far as his being 1 day excess of what was required to be,
Yes.
even in the Supreme Court judgment, while dismissing the appeal, the Supreme Court has said that he should be given an opportunity to make an appeal for condonation because that was never the idea when he applied. When it comes up, that question, it is at that point of time his condonation will be
But
considered. If it is rejected, well and good.
my lord, no, 1 point, my lord. The annexer one that which I have annexed,
What is it?
it says it is not 1 day, it is more than 1 day, my lord. My annexer one. My
It
affidavit
is
in
by the
opposition,
respondent number 8.
8.
What is that annexure? Annexure 1, yes.
My annexer one
Huh?
is continuous page number 87.
87. Yes, I have got it.
So,
How do you
list of
say it is more
rejected
than 1 day?
candidate for subject of Botany.
Uh-huh.
List of rejected candidates for the subject of Botany.
Ah.
Dr. Ahmaduddin, the present petitioner.
Mm.
And reason is overage.
Mm.
So this is issued on 9/9/2019, my lord, by these college of Karimganj. And in the present case, the advertisement was published on 16/10/2019. So a person who is overaged in the month of September 2019,
Where is the advertisement?
advertisement, my lord, annexer, page 28, my lord,
Mm.
of the writ petition.
No, this annexure is in respect of another college, my lord.
Another college.
Another college.
Yes,
No,
another.
no, where do we find out the reference to your age? What is the date on which your age is to be reckoned?
My lord, that is in the advertisement.
Which advertisement?
That is, my lord, in page.
28? No.
Page
Yes,
28, my lord.
28.
So why do you say it is for some other college?
No, this document which my friend has.
Which I relied, it is of
Mm.
Karimganj,
Some other college.
some other college. So in
Sir,
that,
he has given us a date of birth.
yes, ma'am,
Whatever be it, he has given us a date of birth.
yes,
His date of birth is to be calculated to be less than 38 years as on the first of the year in which the advertisement is issued.
yes.
1/1/2019.
19.
Yes, madam.
Is it?
Yes, madam.
Yes.
So 1/1/2019, whatever was his age, he contends that he was 1 day overaged. Is it not?
Yes.
1 day overage.
My lord,
You say, they
Yes.
say 1 day overage, you
Yes,
say
yes.
you are on age, but it is 1 day
one
overage.
day.
That 1 day confusion, whether some other college had rejected it on 9/9, whether he had appeared on 3/10, whether the interview took place in December would not matter when the cutoff date is first of that year. If he was 1 day overaged on the cutoff day of that year, of that, according to that cutoff date, he remains overaged.
Yes, over.
9/9 will not matter,
Yes, yes.
10/10 will not matter.
Yes.
So his number of days will not matter on the date of the advertisement. It will matter, it will depend on the date as given in the advertisement. Is it not?
January 2000.
So now they have argued that he was 1 day overaged.
Yes.
He says, I am on the cutoff. Supreme Court clarifies 1 day overage. And Supreme Court says that if it is 1 day overage, in that particular case, let him make an application, since there is no provision for relaxation in those rules.
Yes.
Let him make an application, government may consider. In our case, there is already an office memorandum saying that the condonation of the age can be sought for, and it has to be placed at the time of the advertisement.
Yes.
This particular case, everybody took him to be within the age
Yes.
till the time he was called for the interview or the document verification. Till that point of time, everybody was satisfied. He is on the cutoff date. He is eligible. So the moment now the issue is settled that he was 1 day overage, it is at this point of time, in the opinion of this court, that he would have the opportunity to make a representation that this is the whole situation.
Yes.
I should have said for the interview, my documents should have been taken into account. Kindly condone 1 day and do it. If the respondents exercise their powers to condone it, he will have the opportunity to sit in the interview.
Again,
If the
they can-
respondents say that I am not inclined to condone it because we already have got better people than you, people who do not need condonation,
Yes.
people have already qualified,
Yes.
why should I give you that liberty? You have done nothing exceptional in your life.
Then
Is it not? Then he goes home.
I'll be out.
But if it is condoned, you only have competition. Is it not? Can you deny competition?
No,
You cannot.
how can I?
Is it? So we'll just let him go through the judgment. If his case falls squarely within this, I'm sure Mr. Abedin is not a person to try and
No,
go around in the to make a jalebi out of a case.
no.
He would be candid enough to say that yes, I'm covered. Is it not?
Currently-
But then a man who has gone through the entire selection process, last stage he comes to know.
My lord, only-
One opportunity for representation is something
Sir,
which,
would your lordship be pleased to see one document, my lord, before your lordship?
Which one?
My lord, my last annexure, that is
Huh?
the comparative
marks,
marks, my lord, in
Huh?
respect of Dudhnoi College, my lord, that is.
the college which you are concerned with,
No.
some other
What-
college, okay?
The same year, what
Mhm.
happened? If your lordship.
You were
see-
given the opportunity to appear.
No, see the serial number 20.
You
Serial
are
number
20.
20, that is me.
Huh?
My lord, the third column question of that 5 marks is there.
5, BA, BSc.
Second, from the last third column.
Teaching management experience, that one.
No. Presentation in a class,
Brief interaction.
that was the only mark available to the selectors
Huh.
earlier.
Huh.
Now it is not there. So over there, your lordship see my 1.21. Did your lordship see it?
Hmm.
The total score what? 62.89.
Hmm.
See the person bold letter, my lord, that is selected.
So mean. 63.91
63.91. See the out of five,
out of,
out of that five, where I got 1.21,
uh,
4.5.
have you challenged this also? No.
No, I did not challenge them.
Anyway,
No, this happened in, this second position happened in 4 colleges with that 5 marks only. In one place, my lord, I got only 0.5.
therefore now in all bona fide, the government has said
My lord.
no such marks.
Take
Isn't
that.
it?
I'm
14.
do that.
Huh?
I'm the last person to do that. Over here, what happened? If I get 0, then I become the topper. The rejection, why it came?
You were you are topping the list.
I'm topping the list irrespective of I get any mark in that 5 mark segment.
No, and we are understanding your situation, the situation of the candidate. But then if this is the Supreme Court law,
No, but
then we
will-
cannot go beyond it. No?
While going through that judgment, would your lordship be pleased to also go through this judgment, madam? দাদা একটু দেখো।
But this is Shimla.
Over there, I think your lordship pointed out only one thing regarding the timing and what time he was born, who knows? If you count the whole day, it is there, my lord, in this judgment.
Yes. No, even in that Supreme Court case, it has said that when you are born on a particular day, it starts at 12 and it goes to 11:59 on the next day.
Over here, this, and my lord, I believe, my lord, in public employment that General Clauses Act Section 9 will apply, my lord. It is applicable.
Supreme Court says otherwise.
No, otherwise it is taken the majority. But if we take the limitation in respect of your lordship is aware fully regarding the
Last
election
days-
petition. Regarding the election petition, I have. the
When you are
judgment
talking
also.
of the, that is what, when you are talking of the General Clauses Act, it is general.
Yes.
He has put up a judgment before me, which deals with age, how to
Yes.
calculate age.
In my.
So what is that, what, non-derogant?
No.
Specially was non-derogant. A general law will not override the special law. Now, when there is a law to determine the age, can I shut my eyes?
No, no. But over here, like, if I take, my lord, then 5 of Limitation Act, which is applicable in respect of
Age.
81 RPA,
Uh,
to and fro, within 45 days.
again, that is not relating to age.
Yes.
Here is something which is relating to age, sir. That is what we are telling you. The
I-
judgment
I
that he has presented before me is relating to age. That is the whole difficulty.
I have gone through that judgment.
Please go through it once again. We'll try to see.
Just take the number, my lord. I'll go through.
No, but you can take the copy which is with the court.
This one.
Go through it. We'll try to have it.
My lord, as your lordship suggested, my lord.
Hmm.
Possible that is the suggestion if I read the mind of the court, my
Hmm.
lord, correctly. Your lordship may either close it or keep it alive. I'll apply within 7 days
Uh,
for that condemnation.
uh.
And if your lordship can put it in the manner, my lord, that within 1 month they will consider.
That is
So if
that
they
we will
consider,
do.
my lord, and let the brief be here, my lord, for 1 month. After that, if they don't,
No.
then obviously I'll
If
go.
either if we send you back, we'll close this. We'll send you back. Allow you the liberty to approach again, in case you have any grievance left.
The interim will continue till then.
Till then. Till then, they would not appoint anybody.
My lord, I'll just take the citation. Rest,
No.
I'll just return.
Just you go through it. We'll take it up when the matter comes. Give it back to us. Give it back to us when the matter is called again.
My lord, I think for today it's over, man. Your lordship may pass the order. If your
Okay.
lordship is giving me the chance to
Go back,
approach, then why should I fight over here anymore, man? I could understand the mind of the court, man. I'll take that opportunity of 1 month. If they don't, then I'm bad luck. Otherwise, if they do, then I have the chance to sit. It's not that I automatically get selected. If he's better, he will remain better.
फिर ऐसा करिए, take it down like this. Heard Mr. Jayabadin, learned counsel appearing for the party petitioner.
B Bora,
Also, huh?
B Bora.
Mr. B. Bora, learned counsel appearing for the respondent number 8. Uh, as thus appearing for the respondent number for the state respondents, Mr. B. Purkayastha,
Yeah.
appearing for the
3 and 5.
3 and 5, appearing for the respondent number 3 and 5. That is only the attendance part. Writ petition is disposed of. We don't write that part. We'll pass the order. We'll pass the orders in the chamber since we have less time here. Otherwise, we dispose it of the on that line. View of the Supreme Court judgment that 1 day requires to be counted. Therefore, he is 1 day overaged. But in these facts and circumstances, he would make an application to be decided within 1 month from the date of receipt. I'll give him 7 days time to make the application.
Yes,
And
ma'am.
till such time, no fresh appointments be made till his matter is decided.
No appointment shall be made in the concerned course.
Timeline may be given with
Ah,
how
wha-
much time it will be decided.
1 week for him to apply
And 1 month.
and 1 month for them to dispose.
Dispose. Yes.
And parties would be at liberty to come back. Any of the parties, they would be at liberty to come back to this court if any grievance remains.
Yes.
All right,
Obliged.
disposed.
Strictly
huh?
obliged, ma'am.
Item 229.
Very clear, Your Lord.
Hmm.
My Lord, that IOCL matter, the petitioner candidature has been rejected on the ground of being overaged by 7 months and 6 days. However, if we peruse the advertisement, clause G specifically, my Lord, 2 kinds of age relaxation is permissible.
Hmm.
One, my Lord.
They had not given you one of them.
Yes.
OBC they had given you, but for the field service or something, they had
Yes,
not given
for
you. Yes.
pedestrian step.
Hmm.
Therefore, my Lord, I applied under RTI. They informed me that I've secured 90 marks, that is the highest at top of the list. My Lord, before that, madam, there are 3 posts, 2 for unreserved, 1 for OBC NCA.
Hmm.
We are concerned with the, at this item number 2, I am concerned with OBC NCA, non-criminal matter. But you will kindly turn to the advertisement at page 27.
Hmm.
Possible kindly see the second row, postcode 202.
Mm-hmm.
My lord, you see at page 27, the advertisement is annexed.
So which cases are we taking up today with the consent of all the parties? Because if we hear, then we hear it properly. We'll try to dispose of one by one.
Prior in
Sir,
context.
can we take it up for disposal?
Yes.
Yes,
Item number?
otherwise, except, I don't know about the status of this particular matter. There is
Huh.
a fresh matter that has been filed.
Hmm.
Item number 9. We have filed our affidavits from our side, pleadings are complete,
Huh.
but other matters are ready. And
Okay.
the one my learned friend is appearing, item
Huh.
2.
Item 9 you are appearing for? You have filed it. So all the affidavits are filed. Anything remains to be done here?
No, he is perhaps saying he has filed the wakalatnama, he need,
Mr. Decca?
Hello.
What do you say?
I appear for.
Should I take up item number 2 for disposal today, whether he should have been granted the relaxation for the particular, what period? That apprenticeship period. If
Folder apprenticeship.
huh, we can dispose it of today that either he was entitled or he was not entitled.
that matter, in fact,
Huh.
I must clarify the position.
Huh.
His case we have admitted, and
Huh.
that is how the other cases have,
So now,
having
is it-
admitted,
so now, so in this case, after noticing.
effectively, according to us,
Huh.
this petition has perhaps even become.
So, no, but he has to get that benefit of being considered for that post. After giving him the
To
relaxation,
that
that,
extent, yes.
that consequential benefit,
That is the only, otherwise we are accepting the fact that his contention is right.
okay, and then we will direct you to take his case into consideration while disposing of
That
the.
can be one way, or maybe a
reselection. Because it
Reselection is
has been
something
a
because
very, very long time.
no,
Election was conducted as far back as in 2021.
what Pradhan, there was some
Right.
Pradhan case, if I'm not wrong, some Pradhan case in the Supreme Court, where this kind of a situation had come up where the selection process had already, it was a long time between the selection process and the other process. Supreme Court had gone to the extent of saying that if he's eligible, appoint him now on
So
supernumerary,
even if he's
just
found to be-
later on.
Even if he is found to be eligible,
Mm.
he can't because there is a further selection process. He was ousted at the very first stage.
Hmm.
So after the written test, there are two other stages which he has to cross.
Hmm.
So even if we consider he has to
And
cross
tho-
those two hurdles,
Those two stages he will be considered for.
so
he'll be
that your
consi-
lordship will take a call.
Otherwise, a total fresh selection will again take away his performance in the written test. May. Huh?
Now I will not be eligible even. Over it.
Now he will not even be eligible. So to
Or
that,
many,
If reselection is done.
a few days back, we were told many people amongst us may be ineligible if we are made to sit in a written test for class 12 now.
yes, not just
Passing of time.
not just class 12, my lord.
Even
That
Even
may
the
be
bar,
difficult.
bar association examination also,
It will be
we are likely to fail.
Or at least we'll have to sweat it out 2-3 days at least. Huh? Okay. Tell us the facts so that
Yes,
we
ma'am.
can quickly declare
Yes.
this order and finish it off.
Yes. My lord, the
At least the
respondent
factual part.
authority, that is the Indian Oil Corporation, put the advertisement that your lordship will find at page 27. Annexure E.
27,
Yes.
okay. So prior to that, you had done your apprenticeship.
Yes, yes. I'm
Where is your certificate of apprenticeship? Okay. Huh.
So, lordship,
Didn't
there
get
are
that
many
right.
posts to advertise.
Junior engineering assistant 4.
Lordship, kindly see, all the posts are junior engineering assistant Roman 4,
Hmm.
but the manner of their duties are different.
You are under PNU.
Yes, power and utility. Lordship will kindly mark this 201 and 202. I am for 202.
Hmm.
PNU means production and utility.
Hmm.
So Lordship will kindly see for Gauhati, 3 posts to advertise. 2 were for unreserved and 1 for OBC NCL.
Hmm.
Am I clear, my lord?
Hmm.
Yes. Now Lordship will kindly turn to page 29. The same advertisement.
You have BSc with boiler apprenticeship, so no further experience is
Yes,
required.
but Lordship come to postcode 201, just above that.
Ah,
Minimum 1 year of post-qualification experience is required.
ठीक है.
In my case, if I have, my lord, BSc with this particular training,
Hmm.
no further experience will be required.
Hmm.
However, down below, for candidates possessing diploma,
Hmm.
experience will be required.
Hmm.
And
Okay.
my BSc certificate, I have an experience.
ठीक है. No, they are not contesting your.
No,
They are
but
not contesting.
the private respondent will come up with this point. Anyway, now Lordship will kindly come to the age relaxation part.
Ah,
That
Page
is, your
33.
Lordship will find at page 33, clause G. Page 33.
yes, for OBC and cell candidates considered against this post will be allowed 3 years. Maximum duration of 1 year will be given to candidate possessing money and being considered for the post of code number 2. So 3 and 10.
3 and 10.
Okay.
10 is specifically, Lordship, my humble summary for postcode 202, not for others.
Others done.
Yes. Now, my lord, when I appeared in the written examination and I was not called for the further selection process,
List of minutes of
I
people.
filed 2 RTI applications, my lord.
No, what is this page 39? First phase of election, selection process.
Yes, that is the result declared by the authority. my lord.
Where do I find this selection process? How the selection would be held?
Now, Lordship. will-
Just a minute.
Yes,
Selection methodology. Admit card for written test will be prima facie eligible candidates, shortlisted candidates. Subject to securing minimum qualifying marks and written test will be required to undergo. So 5 and 7.
5 and 6.
J 5 and 7. Okay. Then you were not called. At page 39, you were not called.
Not called.
Your name does not appear.
That's why I filed two RTI applications,
Now, page 40, your name is not there. Your roll number is not there.
not them.
What is your roll number? Where do we find your roll number? Some document reflecting your roll number?
And, uh,
Ah,
the call letter in the written test, page 37.
30?
37.
7. Huh,
This is the call letter for written test, my lord.
okay.
Roll number is on the top, just above my name, roll number is reflected. Rahul Das, above my name.
Huh, yes, done. You are not called. Then,
Then, my lord, I filed. The first reply to the RTI application is at page 45.
45.
The respondent authorities informed me who was selected,
Hmm.
and the page 46 is the result.
Hmm.
So, Lord, if you kindly turn to page 46.
Skill test, huh?
So, serial number 1 has been appointed for under the category OBC NCL,
With 73 marks in written test.
and he is respondent number
Acha,
5.
this, just for clarification, this skill proficiency and physical test, they are only qualifying tests.
Yes, after the
They,
written test.
they are qualifying or they are based on merit?
No.
That
first-
written test will be merit based.
Huh.
But the skill proficiency or physical test, physical test would be,
That will,
qualifying?
that will also carry some marks.
Yes.
or does it carry marks?
Yes.
Then it was not reflected in page 46 that any
But
marks
because
were
his
there.
query was perhaps only pertaining to written test.
Because I was not called for these two segments, my lord.
Only because he was not called after the written test, so he asked about his marks in the written test.
So, my lord, this serial number 1 candidate has been arrayed as respondent number 5 in this present litigation, my lord. Now, Lordship will kindly turn to page 47. This is the marks I obtained,
Just a minute.
my lord.
Category wise merit list on the basis of marks obtained the written test and authorized shortlist only for such candidates who qualify for, okay. Then, it does not say whether it is a. It doesn't say. No, there are no marks. Just clarifying, sir. Page 33, clause J, columns, serial number 6. I think it does not talk about merit in the other tests. Obtaining minimum qualifying marks in the written test does not confer any right or claim for being shortlisted for so-and-so or the filing selection. As the same is based on candidates rank on the merit list on the basis of marks obtained in the written test. Ratio applied, relative performance, respective category, number of seats, reservation position, candidates meeting notified eligibility criteria, and other parameters and documents upon verification. Okay, any case. Then,
Then, my lord, Lordship will kindly turn to page number 47.
you got 93.
I got 93.
Hmm.
And, my lord, then the reason for my rejection at page 48.
This is the bone of contention. Hmm.
Yes. So they say that I am overaged by 7 months and 6 days.
You asked for the date of birth of others, it was not given to you. That is when you are before this
And,
court.
sir,
Huh?
if a candidate avails, because I am 93, even the general candidate secured less than me. Lordship will kindly turn to page 34, clause 13.
Clause?
13, 1-3.
Page 34 does, 13.
Page 34, 13.
ठीक है.
So, my lord, I have to treat it in OBC NCL only because I
Ah.
have age. avail age relaxation. Yes. Now, my lord, the authorities initially filed an affidavit in opposition
Hmm.
stating that you will not get age relaxation for this clause G10.
Ah,
Then I filed a reply affidavit wherein I annex the judgment of this honorable court,
hmm,
wherein the department has already taken a stand that no, same post, only the year of advertisement was different.
it
Same
could be
post.
given.
So the department came up with a say, no, they will get two kind of age relaxation. That
Okay.
affidavit in reply, I have annexed the coordinate-based order, my lord.
Hmm.
Thereafter, my lord, the department came up with another affidavit admitting that yes, the petitioner's contention is right and he ought to have been considered, my lord. So that is how the matter stands now. My lord, there is one discrepancy in my petition for which I apologize. On the last occasion, lordship has seen my OBC NCL certificate. So the date was after selection process was over.
Hmm.
My lord, this document, my lord, what happened after the written examinations are done? One form is given by the department to get it filled up by the concerned authority.
Ah,
However, there is, so you kindly come to that page number. Page 22.
hmm,
Because the advertisement of was 2021 and this is dated 11/2/2022
Hmm.
down below. Just above the place, lordship has seen number 05082021021
hmm,
001 031688804
Mm.
dated 5/8/2000. That is the actual OBC NCL certificate. So my OBC NCL certificate.
From that certificate, they've given you this certificate, this
No,
form which
this
is.
form is given by the department. Yes.
You had this
Yes,
certificate,
I-
they
and
give you a form, you give this certificate, they issue the form.
Yes.
The,
You can verify this certificate number on top, just the barcode, my lord.
yes.
Then date none down below.
They are not contesting it, we will take it into.
This certificate is valid for 1 year. So, my lord, my humble prayer is that the respondent number 5 appointment has already been interfered with by the department. Now, my lord, the only point remains is that my case should be considered because I was illegally deprived.
Who appears for the respondent number 5? Yes, sir. What do you have to say? Ah, ah, Ah. hmm. Hmm. Boiler? Where is the word competency here in the advertisement? Boiler competency certificate, okay. Eh? No, he has to have a boiler apprenticeship certificate. He is a graduate, sir. So there is no question of competency. There are two different things. One is diploma matric with ITI fitter and holding boiler competency certificate. Second part is BSc with boiler apprenticeship. He is BSc. Boiler apprenticeship is there. What do you say on that? Huh? Whose? Petitioners. Hmm.
However, in such cases, related to what is will not be able.
Period of apprenticeship training in an industry covered under the experience criteria notified in this advertisement. Oh,
Lordship, there is reply to that. Lordship will kindly take up the affidavit filed by, this query came up before this court on earlier occasion.
who?
The department has filed an affidavit on 9/10/2023.
Huh.
Same query was made by this honorable court. What is the status of these two certificates? Lordship will kindly take up the affidavit dated 9/10/2023.
Uh,
By
9-10,
then filed by one Navajyoti Das.
the second one.
Near to 1 to 3 years.
What could 9-10, 2023.
Yes, 2023.
Mhm.
Distant property.
9-10.
Yes.
Respondent number 5, and then we have respondent number 1 to 4. Yes, 9-10,
Yes. Now,
2023. What do they say?
The relevant paras are paras 5 to 8. I will only read para 8, mine. Para 8. It is pursuant to the same query made by the Sonabhu.
You have a copy of this affidavit in opposition filed by 1 to 4? You have not got it. Yes, tell us.
Para 8, man. The relevant paras are para 5, 6, and 7 and 8. I will only read para 8, man. It is submitted that in light of the above contentions, it is unequivocal that apparent that apprenticeship training in boiler trade as stated in proviso 2 to clause B12 of the advertisement and certificate dated 9/6/2019 submitted by the petitioner titled Trade Apprenticeship Boiler Attendant are one and the same for all purposes and considered by the government of any other.
Okay. Now, yes, sir, we could have taken your submissions into consideration had it been a challenge by you. You had pointed out a flaw. The selecting authority says it is not a flaw. Since that is not an issue before us to be decided, we will go by the respondent. Yes. Hmm. Hmm. That is regarding 201. Hmm?
No, requirement is also different. Here, in the advertisement, it says that experience is required, but for post 202, no experience required, required is. Oh, he didn't, it's going to be for me. Okay, that I know.
Okay. You should have, you should have challenged his very candidature then. You have not done that. Can I grant you a relief in somebody else's writ petition? Hmm? You have taken a stand that it may not be considered. Selecting body says, doesn't make a difference, we can consider. Is it not? Huh? So he has yet to go through the second and third phases. Let him cross that hurdle.
Nothing. Text for factual narration, my lord. Page 71 of the, my reply affidavit,
Hmm.
page 71,
Hmm.
as, running page 71, my lord.
Hmm.
This is a coordinate bench judgment wherein the department has stated that two kinds of age relaxations are permissible. And this provision stems out of the Honorable Supreme Court's order, your lordship is already aware,
Uh-huh.
this provision of granting age relaxation over and above the social status,
Hmm.
it's comes out from my lord, the decision of the honorable
No,
Supreme Court.
naturally, if you are getting something because of a particular belonging to a particular class and you have undertaking the same apprenticeship as unreserved categories would take, then why should you be denied that?
Yes.
Therefore, you will be given both. That is the logic, I hope.
Yes, para 12 only, that, para 12.
That should be the, that is what.
Para 3.
If, even otherwise, this, it will be available for both because generals, unreserved category candidate would undergo an apprenticeship and he would get a relaxation.
Yes.
Now, if you are given the relaxation because someone belongs to an OBC category, he is only given the relaxation on the age, then again he is being prejudiced because the apprenticeship relation,
That's
they
why
have to
we
get
do balance.
everything that an unreserved category candidate gets,
Yes.
and they have to get something more.
True, ma'am.
The moment you say you are entitled to only one of them, you are taking away. So that purpose of bringing in an equality, it is hampered. That is what I thought would be given. Anyway.
And my lord, my learned friend submission that if I use age relaxation, if I use my certificate as an experience certificate, age relaxation cannot be granted.
No, this earlier judgment of 2016
Yes.
was not placed before this court.
No, we have, it's on.
No, on the judgment that he is relying upon, two things happened.
Because
This earlier judgment has not been,
1401, the advertisement specifically says.
whatever be the case, this was not
Not
before
placed.
this court, number one, and it belongs to another category, and therefore,
Experience is specifically mentioned.
therefore it will not come into.
And in my prayer, I have said I want relaxation for clause G10. Lordship can peruse my prayer.
And this was G8 and 9.
Yes. My Lordship can peruse my prayer.
Yes, sir. Okay.
I'm deeply obliged.
This is with this order is with regard to WPC 1373 of 2. Please.
The only prayer that can be allowed for the petitioner is that he may be considered as per procedure for the next stages
Mm.
in the, as per the advertisement. But if that particular prayer is allowed today, the writ petitioners in item number 9 and Prana Pathak, who is the writ petitioner here also, I mean the respondent in this particular writ petition, may get affected because all three people are fighting for one post. And
In case we find respondent number 9. Item number 9 is entitled to some relief and he needs to participate. He will participate in the same selection process. What is the difficulty?
But the only, let me clarify.
Huh.
The only difference is, well, the post is same. Item number 2, item number 3, and item number 9. These three posts, item 2, 3, and 9, the post is one and the same.
Okay.
So now all three will have to be.
If the petitioners in 3 and 9 are found to be entitled to relief.
Three is on a slightly different subject matter. He was appointed, and when these anomalies were found, since he was on probation, he was terminated. So now, if there is a consideration, the petitioners in item number 2, 3, and 9 will simultaneously get a consideration.
It is only if he clears the stage 2 and 3
then he goes through.
that he comes into a merit. Moment he comes into a merit, at best, what would 3 be entitled to? A notice that this was the High Court judgment.
That is a separate issue altogether.
Because
there he was on probation. Your lordship is aware.
The probation.
So termination, and it is a termination simpliciter. So the moment we found the anomalies, in fact, what is your lordship is about.
And the only anomaly found in his appointment was his non-consideration or something else.
His non-consideration.
His non-consideration.
Respond number 5 and 3 is same. Respond number 5 in this writ petition and petitioner in item number 3, 1 and same.
Acha. Hmm. Uh, hmm.
No, because of clause 13.
Item number 2. We are not considering item number 2 as of now. You take up that ground when we are in 2. We will see if we can dismiss the writ petition because
So
of
item number 2, you're not just heard.
other just item number 2.
Clause 13, that's what I said.
Huh?
Clause 13 is the answer.
Clause?
13 page 37, my lord. Why I should make them a party, my lord? Because my case will be considered only against the reserved category.
Page?
Page
You are
30
from the general category, sir. You are from the general category. You are not in
Page 34. clause
unreserved category.
Yes.
You are.
Clause 13, page 34. And I did not make them party, my lord.
He will be not considered against an unreserved post under any circumstances whatsoever. So why are you a necessary party? Huh? Huh? But he is an OBC category candidate. He was an OBC category. Then in 3 you may be a party. Well, how can in 2 you can be a party? 2 will only concern with a OBC category. It is the same selection process where petitioner in item number 2 had to be considered against the unreserved category, against the OBC category, was not considered. Petitioner in item number 3 was required to be restricted only to the unreserved category, but was appointed in a restricted only to the OBC category, but was considered for an unreserved category, for which in item number 9 you are suffering. That is the case. Are we getting the correct line? Uh, uh, uh. No, but clause 30 at this thing will not allow that migration.
Page 34, clause 13.
That migration is barred. That migration is barred. You have not challenged that particular Deepa EV. Look up Deepa EV. You will get your answer. Deepa EV. But do you have the judgment? Anyone has the judgment? Deepa EV versus Union of India? Huh? You have that? If it is, huh? No, if the office memorandum says that you cannot go from the reserved category to the unreserved category, then Jitendra Singh will not come in. Jitendra Singh said that it is only to bring you to a level playing field. Therefore, you should be allowed to migrate. There is an office memorandum in DPIV which says that you will not be allowed to migrate. Office memorandum is not challenged. Therefore, you cannot be allowed to migrate. That is the law. And if that be so, you never challenged it, then you will stay back in the reserve category. You cannot go to the unreserved category.
He's a private respondent.
He should not have gone to the unreserved category. Is it?
No,
No.
he is contesting in item number 9. Item number 9, they are saying that.
Let us finish item number 2 kindly.
Yes, ma'am.
One at a time.
Yes, yes.
Last part of that relief, we will keep in mind how to.
One by one. No, otherwise it is overlapping.
Okay. You will find the attendance. Okay, take down.
Lord, may I come back in 10 minutes?
Please. Heard Mr. J. Patwari, learned counsel, appearing for the petitioner. This is in WPC 1373 of 2022. Huh? Then who appears? Mr. I. Chaudhary, learned senior counsel, assisted by Mr. T. Singh, Ms. T. Singh, learned counsel for the IOC, is present. You are Mr. V. Pukon for the respondent number 5. Any more respondents in this matter? No.
Only one post, one respondent.
Huh?
OBC NCL one post. He was appointed.
The petitioner in this petition is a graduate from the University of Gauhati. having obtained his degree of Bachelor of Science with major in physics in the year 2012. Sorry, 2014. Stop. The petitioner also belongs to the class of candidates nomenclatured as other backward classes. And to this effect, the learned counsel for the petitioner has placed before this court a certificate dated 5/8/2021 issued by the Office of the Deputy Commissioner, Borpeta District, with
Last para.
certificate number 050-820-21 hyphen 001 hyphen 03168804. Full stop. The writ petition also contains a format of certificate supplied by the respondent IOCL to the candidates where
On top annexure 6 is listed.
where the petitioner has been certified to belong to a community which is recognized as a backward class under the relevant notifications of the Government of India, and it has also been certified that he did not belong to the persons or sections creamy layer included in the creamy layer mentioned in the relevant schedule to the Government of India DOPT OM dated 8/9/1993. The petitioner, after having attained his educational qualification, had undergone a training course on successful completion of which he was awarded a National Apprenticeship Certificate issued by the Directorate General of Training, Government of India, certifying that the petitioner had undergone appropriate training from 12th of May 2017 to 11th of May 2019 in the designated trade of boiler attendant. Full stop.
Page 25 only.
Huh?
Page 25 only.
What is it? What is it? Another certificate had been issued to the petitioner by the Indian Oil Corporation Limited, certifying that the petitioner had completed the 24 months apprenticeship training as trade apprentice within bracket boiler attendant under the Apprenticeship Act. Full stop. Which I don't read any further. One more thing. This advertisement at G8, which you had said, at G8 says period of apprenticeship training under the Apprenticeship Act will be considered for relaxation in age. Page 26, it is under the Apprenticeship Act. Right? So, even if you go by G8, it was under the Apprenticeship Act and therefore it will be considered for. Then G9 will not come in.
The moment I am BSc, experience is not required. The moment I am BSc, At page, my lord, 27.
This is not required.
Not required. Page 29. Postcode 201, it is required. Diploma, it is required. Not graduation, nothing.
Not required.
Yes, GST with boiler
Hmm.
GST with boiler expense.
Yes.
GST with boiler,
Yes.
no further expense is
Uh,
required.
will not be required. So if he had any further experience to show, that will not be taken into account for relaxation of age.
Boiler,
Uh,
yeah,
so this is not an experience certificate. So therefore it will be considered for age. No. Yes. Okay, either of us is true, either of us is correct. But we'll take the privilege of writing the other that we are correct. Wait, what did we say? Certificate. Okay, then the Indian Oil Corporation Limited had floated an advertisement on 25/9/2021 calling for applications for the post of, amongst others, Junior Engineering Assistant dash Roman 4 within bracket Power and Utility. Full stop. The number of posts shown to be available in IOCL Gauhati was 3, out of which 2 would be open for candidates belonging to the unreserved category, whereas 1 post was shown to be reserved for candidates belonging to the OBC within bracket non-creamy layer bracket close category. Full stop. The qualification and experience criteria given at clause B of the aforesaid advertisement with regard to the post of Junior Engineering Assistant dash Roman 4 within bracket P and U bracket close, the postcode of which was kept at 202 had required the qualification to be a 3 years diploma in mechanical or electrical engineering from recognized institute / university and boiler competency certificate with a proviso that in case of non-availability of sufficient number of candidates meeting the prescribed parameters, candidates possessing other qualifications noted in the advertisement itself, including BSc, BSc within bracket PCM with an apprenticeship training in boiler trade would also be considered for the said posts. Full stop. Insofar as the area of experience for the aforesaid post is concerned, the advertisement noted that for candidates possessing diploma / metric with ITI within bracket fitter and holding boiler competency certificate or BSc with boiler apprenticeship, no further experience would be required. Full stop. The requirements for candidates possessing diploma was also laid down in the advertisement itself. Full stop. However, since the same does not concern the issue related to this writ petition, the same are not referred to in this order. Full stop. The advertisement had also laid down the conditions of the age limit / relaxation for candidates belonging to the SC oblique ST oblique OBC within bracket NCL oblique P small w BD oblique EX capital in the advertisement, the candidate should have attained 26 years as on 30/9/2021. It was informed that as per the available records, the petitioner had applied in the OBC category and was eligible for 3 years age relaxation. But even after the age relaxation, the candidate was found to be overaged by 7 months and 6 days. Therefore, the candidature of the petitioner had been, therefore, the petitioner was declared to be not meeting the eligibility criteria of the examination. The petitioner's request to know the date of birth of all the candidates who appeared for the SPPT under the postcode 202 by this application dated 29/11/2021 was rejected by the IOCL on the ground that the date of birth of the candidates are personal information of the candidates and disclosure was unwarranted under the relevant provisions of the RTI Act 2005. Full stop. It is at this stage that the petitioner has approached this court with the present writ petition, claiming that his candidature had been rejected on an erroneous appreciation of the clauses of the advertisement, comma, in as much as the relaxation which would have been available, which should have been made available to the petitioner because of the apprenticeship undergone by him had not been taken into account by the respondent authorities, and therefore they had not allowed the further relaxation of 2 years over and above the relaxation of 3 years which the petitioner had been granted since he had applied under the OBC within bracket NCL category. By this writ petition, the petitioner has prayed that the respondent authorities be directed to cancel the appointment of the respondent number 5 as a junior engineer assistant within bracket power and utility under the Gauhati refinery, and a further prayer to grant, directing the respondents to grant the age relaxation in terms of clause G within bracket 10 of the advertisement dated 25/9/2021. Was there any interim order operating?
Yes, Lordship, there is no interim order, but his appointment was made to subject to outcome of this petition, while order dated 28/2/2022.
28/2/2022.
And the first order.
Where? There is no order of 28/2/2022 here. 18/8/2022 I find. Which case?
Yes, my lord. By Justice.
Or 28/2/22. Sorry. Is that? Yes. By the order dated 28/2/2022, this court had observed that the appointment of the respondent number 5 would be subject to the outcome of the writ petition. Notices were also issued by the aforesaid order dated 28/2/2022, and upon service of notice, all the respondents are represented. Next paragraph. Just a minute, huh? Mr. J. Patwari, learned counsel appearing for the petitioner, has drawn attention of this court to the relevant portion of clause G, subclause 3, and clause 10 of the same clause to argue that to submit that a relaxation of 3 years for OBC NCL candidates was allowed, and over and above the same, a maximum relaxation of 1 year in age was also required to be given to candidates possessing boiler competency certificate and being considered for the post code 202. Full stop. The learned counsel for the petitioner has submitted that had such a relaxation been afforded to the petitioner, comma, he would have been within the age limit prescribed. Mhm. Has submitted that had such an age relaxation to the age relaxation been granted to the petitioner, comma, the petitioner would have the opportunity to appear in the subsequent tests, namely the SPPT, since admittedly the petitioner had secured marks higher than the person who had been shown to have been finally selected for the post to which the petitioner had also submitted his candidature. Full stop. The learned counsel for the petitioner has referred to the judgment and order dated 26/2/2016 passed in WPC 1307 of 2016, where this court had held that where this court had taken into note the stand of the respondent authorities that candidates belonging to the reserved categories would be entitled to a additional relaxation of age attributable to the period of apprenticeship training undergone by such candidates over and above the relaxation available to such candidates because of their belonging to a particular reserved category. Full stop. By referring to the aforesaid judgment, the learned counsel for the petitioner has submitted that it has been the stand of the respondents in the past that candidates who were situated similarly as that of the petitioner, would be entitled to relaxation in their age twice if they fulfilled the conditions of clause G within bracket 3 and clause G within bracket 10 at the same time. The learned counsel for the petitioner has therefore submitted that the writ petition deserves to be allowed by directing the respondent authorities to grant a further relaxation of 1 year in his age in terms of clause G10 of the advertisement dated 25/9/2021, and after grant of such a relaxation, consider his candidature for participation in the further processes in the selection process. Stop. The learned counsel has submitted that since the appointment of the respondent number 5 had already been made subject to outcome of the writ petition, and the said respondent is also represented in this court, no prejudice would be caused to the respondent number 5 if the petitioner is granted the relaxation and allowed to participate in the further proceedings of the selection process, and the ultimate selection is concluded on the basis of the on the basis of merits, inter se merits of the candidates. Mr. This is next paragraph. Mr. I. Chaudhary, learned senior counsel, appearing for the respondent 1 to 4, namely the IOCL, had submitted that the respondent authorities had filed an affidavit on 27th of October 2022, claiming that the petitioner would not be entitled to the relaxation under clause G10 full stop. In this aforesaid affidavit, a stand was taken that the age relaxation of 1 year for possessing boiler competency certificate is not over and above any other reservation provided for in clause G, in as much as clause G10 specifically stated that the maximum relaxation would be for 1 year, and the petitioner has already availed relaxation of 3 years under clause G3, full stop. The learned senior counsel has further submitted that when it was noticed that the stand taken in the affidavit in opposition was not in consonance with the orders dated 26 with the stand taken by the respondent authorities in WPC 1307 of 2016. Another affidavit dated 16th of March 2023 had been filed in this matter, where the respondent authorities had submitted
Verified.
that the candidature of the petitioner was erroneously denied due to certain discrepancies or irregularities in the recruitment process. In the aforesaid affidavit, another stand had been, it was further submitted that on implementation of the recommendation of an internal inquiry conducted by the Chief Vigilance Officer of the IOCL, certain steps which could also include termination of the respondent number 5 and a reselection of the suitable candidates as per procedure from rejected candidates, which would also include the present petitioner, may have to be undertaken. In essence, it is a submission of the learned senior counsel that the petitioner may be entitled to the 1 year relaxation over and above the relaxation granted to him on the basis of his being a candidate from the OBC within bracket NCL category. Full stop. However, the prayer of the petitioner to be allowed to participate in the subsequent stages of the selection process in question may not be feasible at this point of time since due to the elapse of time from 2019 from 2021, and further there may have been other candidates who had suffered due to the, what did you call it? Due to the erroneous vote. Due to the discrepancy or irregularities in the recruitment process, and those candidates would also deserve a chance to participate in the recruitment process. Full stop. The learned counsel, any other submissions, sir? That would be true. The learned counsel appearing for the respondent number 5 has submitted that an affidavit in opposition has also been filed on behalf of the respondent number
At page
on behalf of the respondent number 5 at page
76, running page 76 is facts. And the 11 portion is para 5, page 82.
no 82, huh? Full stop. The learned counsel for the respondent number 5 has submitted that the petitioner has already been appointed to the post in question, and he has also joined the said post, and he had also joined the said post. Full stop. Now you are terminated, is it not? However, although
Said petitioner has been appointed. Respondent number 5 has been appointed.
that he has been appointed.
Yes.
The learned counsel for the respondent has submitted that, you correct that line, huh? The learned counsel for the respondent number 5 has submitted that he was selected and offered appointment to the aforesaid post, and he had also joined pursuant to such offer of appointment. Full stop. The learned counsel for the respondent number 5 has submitted that although his appointment had been made subject to outcome of the writ petition, in an illegal and arbitrary move, the services of the respondent number the respondent number 5 had been terminated from his services during the period of probation. Now, after the period of had been terminated unceremoniously during the pendency of the writ petition. Where is the termination order? Is it available in this? Had been terminated unceremoniously, and such termination has been assailed in WPC number of 2023. The learned counsel for the respondent number 5 has submitted that the petitioner would not be entitled to the benefits sought to be offered under clause G within bracket 10, since as per clause G within bracket 8, the period of apprenticeship training under the Apprentices Act 1961/1973 in an industry covered under the experience criteria notified in the advertisement would be considered for relaxation in age, and as per clause G9, further period of apprenticeship training in an industry covered under the experience criteria notified in the advertisement relevant to a post would be considered for experience. However, the relaxation towards age would not be available. Full stop. The learned counsel for the petitioner has placed reliance on the judgment of this court in WPC 6253 of 2021. In judgment and order dated 25/11/2021 passed in WPC 6253 of 2021, where this court had resorted to a harmonious construction of clause G8 and G9 of the advertisement to come to a conclusion that as the benefit of age relaxation was extended to the petitioner of that case, the apprenticeship training period undergone by the petitioner therein could not have been considered as experience. Full stop. This court in that case had observed that the petitioner therefore could not have been held to have the required experience for a candidate to be considered for the post of junior engineering assistant -4 within bracket production in terms of the advertisement. Full stop. The counsels for the respondent number 1 to 4, respondent number 5, not 1 to 4, huh? The counsel for the respondent number 5 has therefore prayed for a dismissal of this petition. Full stop. This court has considered the submissions made by the learned counsel appearing on behalf of the parties, and has also perused the judgments placed. Good stuff. In view of this specific stand taken by the respondent authorities, a respondent number 1 to 4 in the affidavit dated 16th of March 2023, to the extent that the petitioner had been erroneously denied participation in the subsequent stages of the recruitment process due to certain discrepancies and irregularities in the recruitment process, this court is of the considered opinion that the petitioner was required to have been given the additional relaxation of 1 year in accordance with the provisions of clause G10 of the advertisement. Full stop. In the event the petitioner had been given such a relaxation, he would have the opportunity to participate in the SPPT, and thereafter the candidature of the petitioner would have to be assessed in terms of inter-same merits with other candidates who had been called in for the SPPT. Full stop. Insofar as the contention of the respondent number 5 with regard to the non-applicability of the provisions of clause G10 of the advertisement to the petitioner is concerned, this court notices that the order dated 25/11/2021 in passed in WPC 6253 of 2021 was with reference to the post of a junior engineering assistant -4 within bracket production, where the requisite experience required minimum 1 year of post qualification experience in operation. Full stop. Where is the other part? The present case deals with a different post, that is the junior engineering assistant dash 4 within bracket P and U with a postcode 202, where the where for the candidates possessing BSc with boiler apprenticeship, comma, no further experience was required. Full stop. This court also notices that in the supplementary affidavit in the affidavit filed by the respondent number 1 to 4 on 9th of October 2023, the respondent authorities have clarified as follows. You quote from page 96, paragraph 8. I have given from A to A. Stop. In the aforesaid view of the matter, this court is also of the opinion that the objections raised by the respondent number 5 to the grant of relaxation of 1 year to the petitioner in terms of clause G10 deserve to be rejected. Full stop. Accordingly, it is held that the candidature of the petitioner had been rejected by the respondent authorities erroneously due to certain discrepancies and irregularities as admitted by them, thus denying him participation in the post-written examination stages of the recruitment process. Full stop. The respondent authorities are therefore now required to consider the candidature of the petitioner for the post-written written examination stages of the recruitment process after granting him the relaxation of 1 year in accordance with clause G10 of the advertisement. Full stop. Full stop. Now this last portion may undergo some modification if we have to adjust with the other candidates. But this is the sum and gist of what the order is going to be. We will make whatever other.
The Lordship indulges my humble praise. Lordship may also include this UP state road. The Supreme Court case I have referred to be included.
I did not find that exact sentence. What does it say?
Because the coordinate bench judgment stems out from this.
If age bar would come in the way of a train, the same would be relaxed in accordance with what is stated in this regard, if any, in the service will concern. That part.
I have referred to this.
But you take this. Where the petitioner was making his submissions, Mr. Patwari has, for the concern, Mr. Patwari, learned counsel for the petitioner, has referred to the case of UP State. You take this one, This one, 1995 to SCC, and has specifically referred to the contents of paragraph 12 of the judgment, which are quoted below. Full stop. The learned counsel has submitted that in consonance with the directions, in consonance with the observation of the Apex Court at paragraph 12(3), the petitioner would be entitled to be granted a relaxation twice, at least for the period for which the apprentice had undergone training. Stop. And at the end, you write, this court is in agreement with the judgment cited by the learned counsel for the petitioner in UP State Road Transport within brackets Supra. We'll add that sentence somewhere. So this is what the item number 2 would be. Now, what was item number?
Whether approach may be adopted for item number 9 because same issue. That candidate was also not considered because of age relaxation.
Item number 9, but he is an unreserved category candidate.
No, no. He is also a OBC NCL. And
Item
na-
number 9. Okay, give us item number 9.
Your lordship party.
Huh.
Just one submission, my lord. My lord, my first prayer was for cancellation of his appointment by virtue of the termination that has been rendered infructuous. Now, my lord,
No.
item number 3.
No, no, you will be in trouble if you do that. In case we hold this termination to be not correct and you give up that part of your prayer.
No, no, I am not giving up. I am,
Mhm,
my
mhm.
humble service is that.
So
in
therefore I said that the end of the order would be
Yes, yes, I got it.
adjusted according to the relief being granted to them. Huh?
What if item number 3 has become vacant? That was
Item number 3 has become?
the adjudication of item number 3 has become vacant. Because lordship is allowing my report.
I am allowing a writ petition to allow you to participate and thereafter consider your, if you do not perform well in your SPPT.
Yes.
Huh?
Did so.
My friend had 3 prayers.
Huh?
Prayer that will be only partially allowed because prayer A would render item 3 infructuous and prayer B.
We have said nothing about prayer 1 now. Is it not? We have only said that he'll be allowed to participate because of the affidavits filed by the respondents. And that he will be allowed to participate. Now, how to end that participation will come after this thing. Because that one paragraph will be added. That these all repetitions were taken up together. Because of the prayers, this is how it is now being tackled. Huh? What would your affidavit say, sir? You knew this case is fixed. You knew this case is part heard. You had this case listed how many times? Now, how many times have we had this case listed? Kindly tell us that on how many times you have appeared in the matter. On Wakalatnama first day. Earlier, without Wakalatnama, how many days? Huh? You are item number 9, respondent number. And that 6 and 7, are they involved in any other case in this series? This is the first time you are appearing. Okay. Item number 9, you are appearing.
Yes.
What is your case?
My lord,
We'll allow you your time if it is found to be necessary. We'll see what is to be done.
Item number 3, my lord. I obtained
No,
79.
you are item number?
Item number 9.
Huh.
My facts are similar to the item number.
Forget
2,
item number 3. You come to item number 9.
2, my, item number 2.
Please stay at item number 9.
My lord, in written test, I obtained 79 marks.
Hmm. You are the general category?
OBC category.
You are OBC category.
category.
Okay.
Otherwise, exactly same.
Same man.
He is the person who has got
Second highest.
second highest.
93, 79 and 73.
And 75. Then why were you not appointed?
Same issue.
Same
Age.
issue, he was rejected.
Similar.
Eh,
Page 61, their affidavit.
Okay. Then
Otherwise, I exactly identical.
now you are in item number 9 in your item. How are you? Why are they parties?
My lord,
Candidates.
Huh.
we have challenged their appointments also.
Why?
My lord, since that, my lord, that the post written test is of qualifying nature.
Eh?
As per the advertisement, my lord, that page 36,
Huh.
J1,
Huh.
the selection methodology will complete.
Ah,
written test.
it will be
will be of
qualifying
qualifying
nature, but
nature.
then the merit will be seen.
My lord, if it carries marks, my lord,
Hmm.
but we are under the impression that the qualifying nature, since it is qualifying nature, then it will carry.
Where will you find
J1, page 36.
selection will be written test? SPPT will be of qualifying nature.
Yes,
Very well. SPPT will be qualifying nature. That is the sentence we were searching and we could not get it.
yes, ma'am, J1 qualifying nature. If it doesn't carry any mark. then
SPPT.
SPPT.
Ah,
There's only one post mark
of OBC.
of OBC.
Ah,
Then the petitioner cell number 2 will be appointed in that post by considering his mark and getting my merit mark. He is getting the highest mark.
who? Ah, yes.
Therefore,
Then
my-
you are out.
Yes, ma'am.
Then you are out.
Therefore, we have challenged the,
Then you are out. How can you go to the general when you have not challenged this one? G3?
Yes, my lord, G13, my
No,
lord.
G,
J13.
J13, you have not challenged J13.
Yes, my lord.
Writ petition dismissed.
My lord.
Thank you.
Yes, my lord. But
Oof,
my lord.
it can be so easy for me.
But he will certainly get a consideration.
Yes.
For what?
Because
for
if
dismissal.
Mr. Patwari's client
Ah.
does not qualify,
Ah.
then he
Then-
has
then-
got
then
secured the
the-
second
Oh,
action.
on that ground, he will be
Yes,
considered.
On
on
that-
that ground. That is the point.
Your
They are safe, my lord, they are safe.
Yes,
that challenge to your selection, we are not interfering. Would you still like to go for an affidavit in opposition? Tell us that.
yes.
No? Huh? No, we will say that he cannot have a, what do you call it?
He cannot have a grievance against the respondent.
Claim. He cannot have a claim to the unreserved posts. As per clause
J13.
J13. And therefore, that part of the prayer is rejected. However, he is similarly situated
Yes.
as the petitioner in WPC number so-and-so, and therefore similar relief. That'll do. Heard Mr. R. M. Dekalanet counsel appearing for the petitioner. The other, Mr. I. Chaudhary, known as senior counsel. Appearing for,
Assisted by,
sorry, assisted by,
he's
earlier
come all
case,
the way from Delhi.
I had said it in the earlier case, this time I forgot. Mr. I. Chaudhary, learned senior counsel, assisted by Ms. T. Singh, learned counsel appearing for the IOCL. Full stop. Mr. appears for the respondent number 6 and 7. All respondents are duly represented. All respondents represented. Who appears for respondent number 5? Pranab Pathak.
Me, Prem.
Same response. He was the one appointed.
Mr. Deka appears for respondent number 5. Full stop. The grievance raised in this writ petition is with regard to the rejection of the candidature of the petitioner by not granting him the relaxation of an additional 1 year on the ground to which the petitioner claims to be entitled to on the basis of the boiler apprenticeship certificate available with him over and above the relaxation granted to the petitioner on the ground of him belonging to an OBC within bracket non-creamy layer candidate. Full stop. The petitioner had obtained his Bachelor of Science degree in the year 2015 and had thereafter completed his 24 months apprenticeship training as trade apprentice within bracket boiler attendant under the Apprenticeship Act at the Indian Oil Corporation Limited from 26/2017 to 19/6/2019. Full stop. The petitioner also has a valid certificate, also had a valid certificate at the relevant point of time, declaring him to belong to a community which was recognized as a backward class under the relevant notifications of the government of India. And it was also certified that he did not belong to the creamy layer persons oblique sections as mentioned in column 3 of the relevant notification of the DOPT OM dated 8/9/1993 or the subsequent notifications. Full stop. The learned counsel for the petitioner has submitted that the facts of the cases of this case is similar to the facts of WPC 1373 of 20, and therefore the petitioner would be entitled to a similar relief. Full stop. On going through the prayers made in the writ petition, this court notices that the first prayer is for setting aside the appointment of respondent number 5, 6, and 7 to the post of Junior Engineering Assistant dash Roman 4 within bracket PNU, comma, the second prayer is for a direction to the respondents to forfeit, recall, rescind or cancel the entire impugn selection. You want the written examination to go, sir?
Appointment of respondent number 567, my page 23.
To forfeit, recall, rescind or cancel the impugn selection and appointment of the respondent number 5, 6 and 7. Oh,
Five is also.
we'll come to that, but tell us where is your prayer to grant you the relaxation?
My lord, page
Where is your
24,
prayer? Huh?
page 24, para 5.
Para 5.
Point
We
5.
appoint you. Can be granted.
Means to appoint a petition.
Can be granted. The prayer is wrong.
In terms of, my lord, that clause.
The prayer
13,
is wrong. You have asked for setting aside of that letter. We'll set it aside.
yes, my lord.
Thereafter, we cannot do anything.
In terms of the clause 13, my lord,
Huh?
this is clause 13, J13.
J13 what?
My lord, I may be considered in that category, OBC category.
You are already considered in the OBC category. You have been given the 3 years.
For further test.
No, you were not given that 1 year relaxation
Yes, ma'am.
for apprenticeship.
Yes, sir.
Where is your prayer to be granted the relaxation?
But my prayer is to, my lord,
Set aside that letter.
set aside the letter and my.
Setting aside the letter, will it set aside the decision?
My lord, but my lord, appointment in accordance with law, my lord.
Huh? Where?
Page 24,
Huh? We cannot ask them to appoint you.
my lord, for consideration.
Supreme Court has said no orders, no directions requiring appointment. Sorry.
For consideration, my lord,
Eh?
entire relief, my lord.
Where? You have only asked for. You have only asked for setting aside of the letter, not even the decision.
My lord, Mulda relief, my lord.
I can do many things. What have you done? Huh? That line we had written now, all the where we had written that part, no? Pray for a similar prayer. We find it. Ongoing through Sakato. Strike out after ongoing through. The next paragraph, the learned counsel for the respondent number 1 to 4, Mr. I. Chaudhary, learned senior counsel, has submitted that the respondent number 5 has already been terminated from his services, and such termination is under challenge in WPC number so and so, which is pending before this court. Stop. The learned senior counsel has submitted that as per the provisions of clause J13, the petitioner who had availed the concession of age, being an OBC within bracket NCL candidate, comma, he can be considered only against reserved vacancies, irrespective of his position in the select list. First, the learned senior counsel has therefore submitted that the prayer of the petitioner to be considered against the posts to which the respondent number 6 and 7 have been appointed do not deserve to be entertained by this court, comma, since the respondent number 6 and 7 are candidates belonging to the unreserved category and have been appointed in that capacity. The learned counsel for the respondents have also drawn attention of this court to clause E2 of the advertisement, according to which the ST/SC/OBC candidates can be considered under the general standard of merit against unreserved post, provided they did not avail the relaxation in age qualification, etc. Full stop. In the present case, it is the admitted position of the petitioner that the petitioner is required to avail the relaxation in age, both as a OBC within bracket NCL category candidate and as a candidate who has undergone an apprenticeship also. Full stop. In such circumstances, this court is in agreement with the submissions of the learned senior counsel for the IOCL that the petitioner cannot, that the services of the respondent number 6 and 7 cannot be interfered with by this court on the grounds put forth by the petitioner herein. Full stop. Accordingly, the prayers of the petitioners for setting aside the appointment, for interfering with the appointment of the respondent number 6 and 7 are rejected. Insofar as the prayer for interference with the appointment of the respondent number 5 is concerned, this court has noticed that the respondent number 5 stands terminated from service by certain orders passed by the respondent authorities themselves, and therefore, in the present case, no directions are required for regarding the services of the regarding the appointment and appointment of the respondent number 5. Full stop. However, this court makes it clear that the merit of the appointment or termination of the respondent number 5 is not an issue in this case, and therefore is not being commented upon in any manner.
No, it is an issue. Because if they have to enter the fray, your lordship would otherwise have to interfere with the respondent number 5.
The prayer of him to terminate the services,
To set aside.
to set
Because
aside the
since your
appointment.
lordship has accepted
Huh.
that they are required to be item number 2 and item number 9, their cases are required to be considered. They are entitled to the benefit of the additional.
We have said that since he already stands terminated at this point of time, therefore, this court in this case is not agitating the issue of his appointment or his termination. We are not deciding that now.
On the merits, yes.
On this case, we are not deciding it. It will be decided in his case whether his termination was correct.
That aspect may be.
That we have kept it. That is why we are trying to keep it aside from this repetition. Yes. Yes. Shortlisted candidate so and so, so and so. Okay. Yes. Even if Pranab Pathak is not out, still, you will do it on your own level. Any number of candidates. See, we will only say that you will be given the benefit of the age relaxation based on the merit of your written test. You will be considered for participation in the other phases. If in 2:1, you two are in, Mr. Deccan, you are in, not Mr. This Deccan, Mr. That Deccan, you are in.
No.
Then you two will participate. If he comes in, he will participate. Whoever is. No, he has been considered in the unreserved category. But
No, he's OBC, man.
he has been considered in the OBC category. He has not been given the opportunity because he has terminated because of your claim. Gun. So one gun. If it is 2:1, one gun. You are the next. He will not even be called.
No,
How will he be
because Mr. Decca has got higher marks.
I am getting higher.
Then he'll come in. Then he goes.
Yes,
We don't know. That will be according to the advertisement on merit. On merit. The final select list will be on the basis of merit. Therefore, we are keeping all the orders half so that we will have to adjust an order. The final directions in each of the case has to be, we'll have to fit into the others. Therefore, the final orders are not being the final direction part is not there in the first order. It will not be here in the second order also. Now we'll say in accordance with law, you find out as many J7s and J8. From 3 o'clock, I am being only taken to J6 and G6. That is more than enough. Okay, what did we say? Last sentence. It is me telling you. There is not an issue in this case. Is not being commented upon. Stop this. However, since the petitioner appears to be entitled to the relaxation of 1 year in age on the basis of the apprenticeship certificate possessed by him, the respondents would be now required to take into consideration the candidature of the petitioner by granting him the relaxation in accordance with the provisions of the advertisement and on the basis of his merits in the written test. Full stop. Yeah, I'll give the rest of the thing once you type this up. Then I'll have to adjust all the prayers. So keep it at that. It is half done, not full done. Okay, so this is done.
Yeah.
So this is now not clashing with anyone. Okay. This is Pranab Pathak. Your termination is an issue here. So here also all are represented?
All are represented.
What is your case here?
My lord, my case was of illegal termination. My lord, after I had rendered more than 1 year of service, my lord, my appointment was terminated, and termination order, your lordship finds at page 40. Now, my lord, of course, I'm challenging the termination on the grounds of violation of natural justice, it being stigmatic in a sense. Then an inquiry also appears to have been conducted behind my back. I was not put to notice at all. Now, with the orders passed in my friend's writ petitions, my lord, perhaps I'll have to confine my prayer to the issue that, my lord, even if they come into the frame, my lord, they will have to undergo SPPT.
Yes.
And subject to qualifying in those rounds, only then they'll be considered, my lord. So there was no point, because this judgment is rendered today, my lord. At that particular stage, my lord, there was no reason to terminate me at all. Because my termination would be necessitated only if they go past that stage of SPPT. And even after that, my lord, assuming that they do go through that qualifying round, my lord, then the entire select list has to be redrawn now, since they are back. Now, if the entire select list is redrawn, my lord, J13 is not a bar for me, because I did not avail a relaxation of age on the ground of OBC.
J13 is not a?
J13 and E2 is not a bar for me.
What was J13? You have it here in your writ petition. Do you have it?
Yes. My lord will have page 21.
J13, when you say
I'm sorry,
J13 is,
It's J12 in my advertisement for some reason.
how do you overcome this?
I've not taken relaxation, my lord.
You have not taken any relaxation. You could have been
Relaxation
considered
40.
against the unreserved category.
No. I had the competency certificate. With that, I don't have to fall back on the OBC certificate.
No, we are saying that since you have not taken any relaxation, you could have been considered against the unreserved category. Okay.
But the difficulty to save time,
Uh,
difficulty would be, he has not made the general category,
I'll come to that.
he has not made them a party.
My lord, to answer that, my lord, that to be confronted with that plea of non-joinder, my lord, that at that point of time, my lord, this was premature. Because this is all subject to them qualifying, Madam. And the,
No.
and the eventuality.
When you are saying that you could have been considered against the general unreserved category candidate correctly,
Provided.
you were appointed as a unreserved category
Unreserved
candidate.
reserve category.
You were appointed in the reserved category.
reserved.
Now your case is that you are required to be considered against the unreserved category candidate
Provided they come in.
only if they come in.
Come in. And only because of the judgment that is rendered today, Madam. Because otherwise there was no occasion for me to challenge the appointment of the general candidates. I have otherwise scored more than them, Madam. Now with the coming of this order today, my lord, now that the select list will be redrawn, only then that cause of action to be considered to in the unreserved category would arise. So therefore, since the select list would be redrawn in any case, provided they go past that SPPT test, well, then let the
Then there were two posts for unreserved category. Your clients would need to have been challenged by him.
Yes.
Or you will be appointed against one of the two posts.
Yes. Or the authorities will at least take a decision. Maybe migration will be allowed, or no, that is again speculative. That if I would have challenged it today,
Okay.
it would have been
We are
said-
understanding your position. Yes.
Not accepting, to be fair to my learned friend, Madam, it has come from my learned friend himself that because of the judgments passed today in item number 2 and 9, now today he is aware of that position. So even today he is required to implement them because of the position that has come about happened today.
Unless you implement them, we would not be in a position to
grant him the
even
relief.
require the respondent authorities to consider you against the unreserved
But
category candidate.
let me put it this way, Manoj. Well, first of all, Manoj, the sequence.
Or we have to tell them that, okay, in considering your candidature, they will have to put the others to notice.
Exactly, man. Because
Not done.
Manoj, why I say so is, Manoj, what
Then they would come back to say that why should the department give us notice? We could have been heard in the court. You have given an order where our appointment is being jeopardized. Were we not sitting in the court in the other connected matters? We were present. We should have been heard.
No, Manoj will leave it open because today, Manoj, that eventually
Or it will be a general order that in case they come and join in your, because you are already out of service, that OBC post is as of today blank.
that
Do
is
you-
also, I have also an interim order not
Are you continuing in service or is it subject to outcome?
subject to.
So you are not there in the post.
Yes.
That post is as of today blank. Now, if one of them comes in,
Yes. Then the question may
then,
arise.
then since we are trying to dispose of the writ petitions in a manner which perhaps will be workable for everybody.
Yes.
Unless we are wrong in law somewhere or someone is aggrieved. Otherwise, if it is workable for everybody, we'll have to make an observation in your writ petition that in case your case can be considered in the unreserved category of that year, the respondents would be at liberty to, you are at liberty to make an application, they will dispose it of in accordance with law. To do that, your representation has to be given to the persons who are already sitting on the posts. Will it not prolong your predicament?
Manoj,
It will simply keep on prolonging. They'll be asking for time in the in the departmental proceeding. There'll be no end to it. Take a chance, make them parties. We can pass this order in their presence, saying that you file a representation, they will reply within whatever time they need to, and the department will take a decision whether you are entitled to be considered against the unreserved post or not. But without them, at least your case will keep pending like this, subject to outcome. Nothing will happen. I am not the person to give an order where persons are present in the court, represented by a counsel, practically, and I will pass an order without them being given a chance to be heard in this.
Another way to look at this is perhaps, Manoj, what the sequence is, Manoj, what they have done is, what they ideally ought to have done is, they ought to have considered maybe their age relaxation, then they come into the fray, then everything happens, and then eventually they find that either of them occupy my post, then they could have terminated. What they've done is, Manoj, they've done.
We'll set it aside today.
So that
We will set it aside today. Suppose we set it aside today. We allow your reinstatement.
Yes.
Say,
Yes.
we allow your reinstatement 2 months
Subject.
down the line, they come in. Where do you go?
Well,
It's already subject to outcome. You are not having a relief. For a 2 months relief,
True, true, my lord. But then, of course, if they take a decision, then I can always come back, my lord, fighting it out.
You would still not be there, because once if they come out more meritorious than you, the first thing that we are going to refuse is an interim. Because more meritorious persons have come under orders of the court. I would not allow you to continue. When I say this court, I mean this court. I would not allow you to continue. Is it not? Now, when we do not allow you to continue, your agony will start 3 months hence. When you will be filing a writ petition, when you will have to be giving notices and this and that, everything will be in chaos for your life. You have them in this writ petition now. It will be an agony for maybe 1 month more. But yet, the relief will fall faster to you.
But if the termination order is also examined in isolation, my lord, without, then also, I would say prima facie it should go, my lord.
Once you had other competitors to that particular post who did not get a genuine consideration and who had secured more marks than you, and when the advertisement says that SPPT is only qualifying in nature, they qualify, they have scored higher than you are bound to be out. Even if I put away that termination order on the grounds of natural justice.
Yes, yes.
Is it not?
Yeah.
So
That I agree.
when you are standing up before this court, or when we are trying to deliver a judgment, it has to be something which the petitioner can hold. Is it not? A refusal or a grant of an order which he can work on. Today, setting it aside would be a big joy for him.
But even
Eventually, one of them is going to come up if they qualify. What happens? Everything will be in a chaos.
and then if they don't consider, my lord, my migration, if they do come in, my lord,
But
then
in the meantime, you would be out, and your consideration of migration, this is a 2022 writ petition or 2023 writ petition. We are in 2026. The next 6 years or 4 years, he's out of job, waiting for a result, which can be done now.
But then even the other way around, my lord, if to keep this pending, get respondent number 6 and 7, my lord, by then they occupy.
So therefore, by that, if you get them into position, we find that you were more meritorious and you were required to be considered against one of them. A specific direction can flow in their presence. In their absence, it is only granting you a relief to file a representation.
And they are.
But if they are present before this court and you can show that you had more marks and you were required to be considered as an unreserved category candidate, it will be upon them to show that no, you cannot oust us like that. If you have a better chance on that. But without hearing them, I can give that order.
No, but why I say that is, Lord, like today I have been submitting that I have already rendered 2 years of service, which is why I should have at least been.
All said and done, if more meritorious candidates come in, ultimately that will be the ultimate choice. Your termination, whether it is right or wrong, is limited to you. A selection process, whether it was correctly done or not, is a larger issue. The larger issue will overshadow the private one. Think over it. I'm ready either ways. You want a representation disposal, I can say that this termination was probably not correct, natural justice and all that, or I may say that yes, under probation it was correct. Whichever way, your ultimate relief of being considered against the unreserved post will happen only if the unreserved category candidates are before this court. Then it is either a yes or a no. Otherwise, it is them for them to decide 6-7 months in deciding. You are in the air, then you come back, notice issue this. Huh?
Perhaps we can take our chances.
Because I'm not directing a reinstatement when already I have said that they would be first considered for this thing. You are not being given a chance. You had notice of this case, of this particular case. In your presence, they are being given the opportunity to participate further. Therefore, filling up the post now or reinstating you now, unless the respondent says that we don't have anybody else to act for, please let someone work. Unless they come up with the stand, I am not inclined to grant you, to let you to continue. Because you are holding a post where you did not qualify in appropriate in a proper competition. That issue comes in.
They have now come up with the contention that it was their erroneous appraisal or whatever.
Whatever.
So
For
therefore,
that, you should not have suffered, but what is the practical answer to it? Legal answers?
so now that the select list is going to be redrawn in any case, my lord.
Hmm.
So therefore, when they while they redraw it, they have to.
In his case, your appointment was subject to the outcome. In your
our
case, your termination is subject to the outcome.
So therefore, my lord.
But think over it. We have little time today.
In fact, my lord, what has fallen from your lordship is the suggestion he should take either of these two for the simple reason. If he gets too technical, I must point out, this is for my friend's benefit.
Hmm.
If your lordship comes to clause J7,
Hmm.
after the written test, we are required to call for SPPT test in the ratio of 1:2, one post, two persons.
2%.
So Mr. Patwari and Mr. RM Deka's clients have got higher marks than him.
So he goes out anyway. He's not even to be called for the SPPT.
Exactly.
You will not have a claim to the post, sir.
So-
Your only claim is in the unreserved
therefore,
category.
But it
If
says
we go by this
qualifying.
clause,
Huh?
Perhaps it's qualifying.
What qualifying?
no. In fact, going by this clause, your lordship has to allow by setting aside his appointment.
Hmm.
In Mr. Patwari's case and Mr. RM Deka's case, if your lordship takes into account this clause, his appointment needs to be set aside. Because he
And
was
that is what you have
totally,
done. And that is what you have done.
that is why
More
we have
than
to terminate.
more than natural justice, this it will become an empty formality.
Empty
because you
formality.
was-
Exactly.
See, these things will fall.
No, because J7, my lord, though it's talks about that 1:2 ratio, it says subject to securing minimum qualifying marks in the report.
When you are being called, they have secured more than you. Can it be a standard? They have not qualified, they have not got the minimum qualifying marks. When people lower in you in merit have been called for the unreserved category, can it be said that you did not secure the minimum qualifying? 100% you have secured. 100% you'd be there. You have already, your another stand, now I don't know I should do this or not, but your understand is you have already qualified the SPPT.
Yes.
So it is only the marks in the unreserved category that requires to be considered for you. But in the absence of the unreserved categories, khatam shudh. Period. Full stop, period.
My lord will keep this.
Think
and-
it over.
My lord will keep this and segregate the rest.
No segregation.
My lord, the other ones,
Which one?
6 to 8.
Who is 5 to 5 to 8 is what?
5 to 8 is a termination on other grounds. My lord.
Whose termination?
Are not related
Those are
to
different.
OBC.
Those are different
age
candidates.
relax-
So what, just to make it easier, Manoj, what happened was,
Just a
Mis-
minute.
Mr.
Let us
Patwar-
understand. We'll come to a solution, don't worry.
Mr. Patwari's client and Mr. RM Deka's client, before coming to this court, they also lodged complaints.
Okay.
And immediately thereafter, these writ petitions also came. So we thought that let us examine whether there is any truth to these complaints. Once we started examining this entire recruitment process, we found that not only his case, there were some other candidates in respect of whom there were some errors committed. And those 4 are those people where we found that wrong marks were allotted,
Okay.
wrong certificates were taken into account. So those also, since they were on probation, those also we terminated.
Okay.
So
So
those
let us-
other
let-
4 writ
no,
petitions are.
Let us not, because earlier there were orders of segregation of some cases. Then we had to again bring them all together.
No, my lord,
To
I
understand,
had
then
made
again-
that prayer, your lordship said will consider.
So what we do is we don't segregate as of today. Like we have taken up 2 today, tried to dispose them off in a
Yes.
particular line. We'll take this up also.
Yes.
All the 3. Whatever is connected. On the next date, we'll pick up this one. You have your instructions. By that time, if you are under instructions to implead anybody, file your application so that on the next day we can issue notice or do something about it. Otherwise, we'll go by what has happened today. The discussions are very clear. Your not being given this natural justice may be overridden by the fact that there was a admitted mistake in the selection process. You were not the only person having the qualifying marks. 2:1, you may not have been there at all. Therefore, this allowing you a natural justice now would only be a mere formality. One view of it. Exactly opposite view, whether it's a mere formality or not, procedure of law had to be followed, was not followed. Then what? Already another 2 persons are being, so therefore, till such time, you will be under consideration, but not appointed.
For termination goes.
But the termination was not correct. But we cannot allow a reinstatement because of the change circumstances, isn't it? Have your instructions. Convenient date.
4th of June. Can it be on 4th of June, my lord?
4th of June is subject to everybody's convenience, no difficulty.
In between, last 2 weeks continuously, I'm away.
Huh?
Last 2 weeks of May.
26.
No, I'm on 9.
Because on that day, if he comes up with an implement petition,
Hmm.
it is only issuance of notice, we are not
Yes, yes,
deciding anything.
yes.
So
But
if
the
we put
rest
it up
will
on
be-
26th of June also,
But I am,
well, when we will not be taking up the other issues, perhaps. you
but
can
in
be on
case
this-
your lordship wants to take up the other 4 writ petitions, then
We will, it comes before us, we will not do it. We will
Then-
not
then
put
your
anybody to a
lordship
disadvantage.
have
Those
it
can
on
be
a-
decided at any other point of time.
Okay.
First, this mess needs to be cleared up. Then we'll go into individual, this thing. Or 4th of June, what is the difficulty?
4th of June.
4th of June?
Say the 9th of June.
9th
দুটা disposal, huh? Item 2 and item 9. Item 2 or item 9 disposed. Yet likhok, heard Mr. Deka, learned counsel appearing for the petitioner. This is in item number 3, Aru? 3, 4, 5, 6, 7, 8. 3, 4, 5, 6, Mr. Deka, learned counsel appearing for the petitioners in all the writ petitions. And Mr. I. Chaudhary, learned senior counsel, assisted by Ms. T. Singh, learned counsel appearing for the IOCL, full stop. 2 writ petitions connected in this series have been disposed of today, full stop. At the request of the learned counsel for the petitioner in WPC 1069 of 2023, list the matter again on 4th of June 2026.
and in the other cases, huh?
5th.
5th হলে আবার Friday হবে। Friday হলে আবার
Hmm?
কতটা হবে আমি মিলাই নেব।
Other matter.
They come together.
Yes.
They
On
come
that day, your
together.
lordship will take up.
And then that day, if we can do something on this matter, it is better. Otherwise, individually, if those can be decided,
Yes.
if the points of law are such that we can decide each one of them one by one, we'll decide it. Huh? List these writ petitions again on 4th of June. Huh? Writ petition number kita likhi dibo khali.
Right.
Thank you.
Item 10.
Huh? Yes, madam. He says 11 months behind bar. And he says, notice section 35, 36.
36 arrest memo.
Arrest memo, not in accord. You jump to another point. I try to touch that point, you
Yes,
jump to
madam,
another
yes,
point.
but
That is not how bails are taken.
I have not found a document.
You are a very familiar face to me, is it not? You have been appearing in so many matters. Is it not?
Mine,
We have been considering every bail possible.
mine.
So we expect you to go to answer what the court is asking.
There is the
Because you see, a car is better driven when you are driving it nicely, slowly, with
Mine.
good control. If you think those racing cars skidding is going to help in every, it will not. Will it? There's going to be a crash one day. So don't do that. Have your grounds properly made. When we have asked you that the FIR is at 9:30 in the night, is it not? You're picking up, even if we assume is after 9:30 in the night, you were produced on 20,
Yes, ma'am, produced.
correct?
20.
Now that 47 and 48 notice, they have been sufficiently given. When?
On 26.
On 26. If your father was there on 19 when you were picked up, should have been given then and there.
No, madam. The signature of the father or the guardian were not taken the arrest memo. This is my plea.
May not be.
Section 36.
May not be. When the father or the guardian in your own statement was there with you when you were picked up. What is 36 for? The signature of the guardian when? Why is it there? On Monday, list accordingly. Monday, try your luck on Monday. Too much of time.